Good evening. Thank you for joining us this evening for our two-part webinar series, Financial Abuse 101. I'm Rachel Marks. I serve as the Vice President of Shalom Task Force, and I'm affiliated with the law firm of Schoenfeld and Goldring. I've been practicing now for 17 years as a litigator, and I am very excited to be joined this evening by Erin Bistricer, who joined Sarah's Voice in 2012 and is the senior staff attorney. Throughout her career at Sarah's Voice, Erin has litigated numerous complex family law matters in both family and Supreme Court. Erin works exclusively with low-income domestic abuse survivors and provides services with respect and empathy to the particular challenges they face. In addition to litigating custody and visitation cases, Erin has substantial experience working on financial cases involving child support, spousal support, maintenance, and property and debt distribution. These cases often involve situations where the abuser is earning off-the-books income and is trying to hide assets. These cases often overlap with other areas of law such as tax, foreclosure, employment, and housing. Thank you for joining us this evening, Erin. Tonight, we are going to be discussing financial abuse. A common question often encountered while working on domestic violence cases, I see it in my own practice, which I don't think I said. I do matrimonial and family law as well, and Erin certainly sees it every day. People always ask, why does a survivor stay in an abusive relationship? We know that it's not an easy question to address, as there are many factors for each individual survivor that go into the decision about whether or not to leave. However, one of those factors are finances. Domestic abuse survivors are at a higher poverty risk. Abusive practices can leave the survivor in a vulnerable and a financially insecure situation. Without the support to set up an independent and stable household free of the abuser, many survivors may choose to stay in these relationships. This concern and the complex issues surrounding it is the impetus for this webinar series this evening and next week as well. At Sarah's Voice, Erin deals exclusively with cases involving domestic abuse. So good evening, Erin. When you approached me a few weeks ago about doing this webinar, you were very passionate about addressing financial abuse. Please share with us why.
Thank you, Rachel, and thank you for agreeing to do this webinar with me. I know in your practice you deal a lot with financial abuse and really complicated issues regarding divorces, equitable distribution, and all those financial issues that we're going to get into tonight. So thank you for lending us your expertise as well. So the reason I was very eager to do this webinar is because financial abuse is one of the most prevalent forms of abuse that I see in my cases, but it's also one of the most challenging forms of abuse to establish, and it's really misunderstood. So I wanted to put together this webinar and hopefully spend some time really giving this type of abuse the attention it deserves. Education is really a form of empowerment, and I find that education and financial literacy is the strongest and best tool to combating financial abuse. So I'm going to share a slide just to give an overview to everyone about what these webinar series will be covering. So if you just bear with me one moment. Here we are. So for today's presentation, I really want to focus on the nuts and bolts of the family court and the Supreme Court systems. What kind of support is out there? What is child support? What is maintenance? This term equitable distribution, what is that? So to really go into the final points of what people's rights are in the court system. And this is to hopefully give the information that is necessary to understanding how abuse will actually play out in the court system, which is really what we're going to focus on in the second webinar, which is next week, August 17th, which is going to be more of a dialogue between me and Rachel about how these abusive practices that we see in our cases actually manifest itself in the court system in these contexts of support, divorce, maintenance, And, you know, what strategies can we start thinking about now, whether or not you're still in the abusive relationship or after you're in that abusive relationship? What kind of financial practices can you do to help protect yourself in court, and what you can do to make it so that when you actually go into court, you'd be in a better position?
Great. So as you can see, they're really these two-part series. They're building blocks here. This week, we're going to be introducing the financial aspects of a divorce, support, as Erin said, equitable distribution, discussing finances generally, and then we're going to be narrowing in a lot more next week and bringing in the abusive elements, tactics, and what we can do about them. So it'll take a little bit time to get there, but each step is really important to provide a full picture of what the system looks like. Just some housekeeping. We've already received many questions prior to the beginning of the start of our program. You can submit questions through the Q&A feature. Please note that if you want the questions to be anonymous, make sure to mark the anonymous option before you submit. If you are on the conference line or watching through Facebook Live, you can submit questions by visiting shalomtaskforce.org/FA, the letters FA 101. We've already received a number of questions. While we are unable to advise on specific case facts, we will be exploring the legal issues that frequently arise in financial cases. And because of time constraints, we will not be able to cover everything. If you would like to discuss your case in detail or have questions related to case financials, please contact Sarah's Voice. The information will be up at the end of the webinar. We'll leave that there for a little while, so you have all of our contact information, website, phone numbers, text lines, and all of that. In addition, our hotline, chat line, is open until midnight tonight. That is not for legal questions. It is our regular Shalom Task Force hotline and chat line. Sarah's Voice does have a chat line as well, and that is available during business hours of 9 to 5. Okay, this program is also being recorded and will be available on the Shalom Task Force website under Legal Services, the Financial Webinar page, and under our Resources, the video page as well. Okay, let's begin. So again, tonight we're going to be discussing abusive practices during and after a relationship and the challenges they present, and we're going to address how to tackle them. So let's just jump right into it now. When we are talking about divorce, most households, quite frankly, can't afford it. There isn't enough money to go around. We're taking one household, we're dividing it into two. And it's a challenge to figure out how each party will meet the financial needs, their own needs and the needs of their children if there aren't children there. Nearly every consultation that sits across the table from me always wants to know, what are my rights? What am I going to be getting? How am I going to support myself and my children? How am I going to do this essentially? How can I make this work? So Erin, what are people's rights vis-a-vis support in a divorce? And how do we help our clients realize their rights and achieve their goals?
So there's several, I always like to divide it in my head into three main categories. I'm going to start with the first two. So one is child support and one is spousal support or maintenance. These are the kind of monetary value or benefit amount, if you want to think of it that way, that you're entitled to if you separate. And they're calculated very differently. So this is a cash amount that you would get from the other side each month. The first is child support. And this is based on a formula. I'm going to zoom in on the formula right here. You can see it's dependent on the number of children that you have. It's also dependent on the non-custodial parent's income. So what the courts do is that they look at the non-custodial parent's income after certain kinds of taxes are taken out. So for example, if they're making, let's say, $50,000 a year, but after certain types of taxes, they're earning $40,000 a year. They'll take the percentage of that 40,000, and depending on the number of children that you have, that will be essentially your cash amount that you're getting in child support. The caveat to this is this number right here, which I'm going to zoom in on, the self-support reserve. If the non-custodial parent is earning less than this amount of money, the court deems that person as earning too little income to actually support the non-custodial parent's needs. And in a case like that, the child support won't follow this calculation that I just laid out, like 17% for one child, 25% for two children. It will just be a flat $25 a month. So that's, I think we could all agree that the number is laughable. It's not enough to survive off of, but it is how the court actually guides itself when the income is that low. And this can be a key litigation point when you're in court. That's basic child support. The second kind of support is what's called spousal support or maintenance. Spousal support refers to the type of amount of money.
I'm going to interrupt you 1 second.
Yeah. Mm-hmm.
But it's also an older term is alimony. People often
I was going to get to that. Yes.
Alimony. Yeah.
Yes. It used to be called alimony. It's now called maintenance. Spousal support refers to the amount that a moneyed spouse would have to pay to a less moneyed spouse during the actual marriage, hence the word spousal support. But post-divorce, it's now called maintenance, which used to be referred to as alimony. And that's what a lot of people know it as. So thank you, Rachel. Spousal support is very different than child support for one main reason. Child support is mandatory. If you have children, an amount has to be ordered for the custodial parent to pay. Whereas spousal support is not mandatory, the courts don't have to order it at all. But the courts do generally guide themselves based on another formula, which honestly, it's too lengthy and complicated to explain over this webinar. You can see it in this slide over here. Essentially, they're looking at a comparison of the moneyed spouse's income juxtaposed to the non-moneyed spouse's income. And they also change the formula if there's children involved, which is what these boxes over here. But essentially, just a really easy way to know if you're entitled to spousal support is to plug in the numbers on this calculator, which you can find on the court website, which will also be on the Shalom Task Force website. And if it will do the calculation for you whether or not you're entitled to support. So essentially is that spouse has to be making significantly more money than you. And then the second issue is how long was your marriage? They have a formula to determine how long the spousal support or the maintenance will last. It doesn't last forever. And the longer you're married for, the longer it will be. But if you have a short marriage, which the court considers anything less than 15 years, you're not going to be entitled to maintenance for very long. It could be a couple of months to a couple of years, but it's not going to be something very lengthy. Even if the guidelines say that an amount of spousal support is justified, the court still might not order it because they have a whole other list of factors they can consider to essentially decide if it's fair to order one spouse to support the other. And those factors really have to do with earning potential, who the custodial parent is, the age and health of the party. So for example, if someone's nearing retirement, they might not feel like it's fair to order that person to pay spousal support if they're right about to retire. So there's a whole bunch of factors that the court can look at. But in essence, they are guided by the guidelines, but there's always a caveat. I just want to make a quick point about COVID under these circumstances is that right now with COVID, it's very difficult to file. I mean, right now in New York City, at least, you cannot file for child support or spousal support and actually get it calendared unless you're doing this through a divorce. And we'll talk more about that later, but I just want to make a clear note that it is harder right now to access the courts. But once you do access the courts, the standards are still the same. They have not been impacted by COVID. The only question is the non-custodial parent or the other spouse's income, has that been impacted by COVID? So because in general, people have been losing jobs recently, there has been a lot of disputes in my cases over what the income actually now is. And I want to say that unemployment benefits, which unfortunately is a large source of income for many people right now, is considered income and can be counted as part of these calculations.
Okay, thank you, Erin. That's a good point. You made a good point right now when you said that that unemployment would be counted as income. Another thing that I'd like to point out is that when computing child support and child support add-ons, which we're going to speak about in a moment, maintenance will be counted as income as well.
Yes, that's a really good point.
Maintenance becomes the income for the person who is getting it. Okay, so for example, a wife is getting maintenance from husband, and it can go either way because it depends on who's making more money and this whole calculation. If wife is getting maintenance from husband, then maintenance becomes her income, part of her income. So if she has an additional job outside the home, it would be tacked onto that. If she does not have a job outside the home, that becomes her income. Okay, so that's an important thing. That's an important point there. And as far as child support, well, everyone wants to know, what's child support supposed to cover? What is it for? What does it cover? And it's very simple, actually. Child support doesn't cover all that much when you're talking about the expenses of raising children. It covers the biggies, though: food, clothing, and shelter.
At least it's intended to cover that.
Yes.
It might not be enough to cover it, but instead of the court ordering the person to pay, let's say, your housing costs, your food costs, or your clothing costs, they're going to give you a lump sum, whatever that is. You're using that to pay for the biggies, as Rachel said.
Correct. So it's food, clothing, and shelter. So what's not included there? What's not included there in the child support is tuition, camp, medical expenses, out-of-pocket medical expenses. You may have insurance, but then you may have co-pays and medications, deductibles, and all of that. Childcare expenses, extracurricular activities. All those things don't come into the limited category of child support because they are not food, clothing, or shelter. So those things fall into what we call add-on expenses. And we have mandatory add-on expenses and non-mandatory add-on expenses. What falls under mandatory would be child care for when the custodial parent is at work or traveling to and from work, and healthcare. What would fall under non-mandatory is tuition, tutoring, camp, extracurricular activities, everything that is not food, shelter, clothing, childcare, healthcare. Okay, so all other major expenses would fall under that non-mandatory category. How does the court deal with that? How would we deal with covering those expenses? The way we would do that is by establishing a pro rata, doing another calculation. A lot of this really calculation, and I always have a calculator with me. And ironically, I became a lawyer because I don't like math, and all day long I'm doing calculations.
The joke was on us.
Seriously, because all day long I'm doing calculations. And what we do is we figure out a pro rata, okay, based on the both parents' income from all sources, and we'll be talking about imputation of income shortly. So income from all sources, we determine what the pro rata would be. So it might be 50-50, 60-40. 75-25, 90-10, and any other variation. And based on that, you would break down how those expenses would be paid. And when you're talking about, when you're trying to work out a settlement and you're outside of court, all those things are, things that can be tweaked and discussed with your lawyer and factored into the big picture of a global settlement. There's a little, there's more wiggle room in figuring out those things than there might be in your direct calculations of child support and maintenance, or spousal support as well. And that, by the way, those things are called direct support as opposed to add-on expenses.
Yeah, that's it. That's it. Another word is basic support. That's a good point. Right. So it's a little confusing. There's the basic support, which is the cash amount, and then there's the add-on expenses on top of that. And I want to point out that with the add-on expenses is where the custodial parent's income really comes into question. So a lot of times I get clients who ask me, well, why does my income matter? I'm the custodial parent. Isn't it true that my ex-partner needs to pay me? So it's their income that should really be the focus. And yes, that is true for the basic support amount. However, when it comes to the add-ons, the shares, it's a completely different calculation, because now it looks at the combined parental income and they compare, essentially proportionally, each parent has to pay their share towards it. And that's where the custodial parent's income is very important, because it determines how much of the medical expenses or the childcare or the educational expenses that parent will be paying.
Absolutely. And one of the very big expenses within the Jewish population that you and I both deal with often is tuition. Okay, you have yeshiva tuition, Jewish day school tuition, and it's a lot of money. Okay, depending on where your children are going to school, how many children you have, what level they're at. I don't want to say it's a burden on the family because it's our tradition and our pleasure to do so, but it is quite a financial burden. And parents in a divorce have to figure out how that is going to be paid for. Will a parent receive an order for tuition? How would the court deal with tuition.
Okay.
Remember, it's for religious education.
It is for religious education, or for example, it's really, the law is for any private school technically, but in the context that we're talking about yeshiva religious education. And this is a really, at least for me, it's a very interesting field, because sometimes you can have a really easy agreement on the basic child support because all you have to do is look at the numbers and make the calculation. But tuition's not like that because it's not a mandatory expense. And this is where you can start getting into arguments. And this is where you might have to start making concessions on maybe, okay, I won't take spousal support because I'm only going to get it for 2 or 3 years, but I'll waive that in return for something for tuition. Now, tuition's not mandatory because the way that the courts look at this is that if there's a free option available, in this case, public school, why should I order a party then to put out all this money for private school education? And the reason for that is that I think that we all know in the community, like Rachel said, this is also for religious education, which is not something that they're going to be able to get in the public school system. So the court has a standard that they look at, and essentially that standard is when justice requires it, that is when the court will order the non-custodial parent to pay for tuition. And what does that mean? That's a really vague term. What does justice requires mean? So there's case law on this that really fills in that gap as to when a non-custodial parent should have to pay for tuition. And I wrote them out over here in the slide, but essentially they're looking at the facts of the case to see if private school tuition makes sense. So for example, the parties' respective educational histories, if we're talking about 2 parties who both went to a yeshiva when they were growing up, and they have this educational history. For example, this also applies to college. If these are college educated parties and you're thinking you're raising the kids in a certain kind of lifestyle that fits that education, the court might be more inclined in that case to order those parties to pay for their child's private school education. In addition to that, special needs. So if the public school system is not going to be able to meet the needs of the child, that is also a very strong argument for why private tuition should be ordered. It could take into account, this is a really big one in my case, is the family's religious values and whether or not there's case law saying if it's the central part of the family's lifestyle. If you have a family revolving around Shabbos and kashrut, you would expect then the child to then go to school to learn what those rules are. If they're raising them in an Orthodox community where the whole community is centered around the synagogue and the people that you associate with who are all also living that Orthodox lifestyle for social reasons, the court might say it's best for this child to attend a yeshiva. If there was an agreement between the parties, and if it was an oral agreement that you can kind of establish the lifestyle that you're living, we both agreed our child was going to attend this school. And this is easier the older the children get, because if they're already in the school and if that's established, and especially if there's establishment of payments coming from both parties or one party, that's crucial evidence of showing that, you know, this party was on board with tuition until you got separated. And that's really damaging for that party, that level of facts. But ultimately, at the end of the day, the court is going to look at the financial means of the party. Like Rachel says, when you're dividing a household, sometimes there's just not enough money to go around. So even if you have strong facts in your case, you do need to consider is tangibly, is the money there? And that's why the tuition payments in the past are so crucial in establishing whether or not this is something that the parties can actually afford.
Exactly. So it's really important to establish all of these facts, and your attorney would do this during a deposition, ask questions about the age of the children, where they've gone to school since they began school. You know, it could be from 2-year-old, religious, a Jewish playgroup, a Jewish neighborhood playgroup. Where did they begin school? How old are they now? Your attorney will even go as far as to ask you about your religious educational upbringing. Where did you go to elementary school and high school? Did you spend any time studying a gap year? Did you take out any time just for religious studies? All of those things. And it's all very important to establish that there has been a history, a rich religious history in the home that would warrant a continuation of that. And like Erin said as well, having discussions between the parties going as far back as dating. When you dated, did you discuss what your household would look like? Would you be having and holding Shabbat dinners? Would you be observing all the Jewish holidays? Would you be sending your children to religious school? And then what steps did you take after that? So the older your children are, the more established they are, so it's somewhat easier, but it doesn't mean that it can't be done for younger children as well. And that's, we see a lot of cases where the parents are, one parent may say that they don't want to pay. They're not going to pay. And they're using that. And we'll discuss this, when we start talking about financial abuse and using things as a tool and manipulation and all that. A parent can be using tuition, and I see it all too often, as a form of manipulation, trying to manipulate.
And it's also a backhanded way. But I understood you. I got you.
Thank you.
It's also a backhanded way to, in fact, we talked at a previous webinar about what custody is and making decisions for the children. And one of the biggest types of custody is legal custody and where the kids can go to school. If you're choosing the school for your child, but you can't pay for that school, this is a backhanded way of trying to get you to go along with what the abuser wants the school to be. They might say, I won't pay for that school, but I'll pay for this school. So even if it's your decision, just keep in mind, I'm not paying for your decision. And that's really where a lot of stickiness can get involved. I also want to point out that sometimes it's the custodial parent who does not want the child going to yeshiva, or it could be that the custodial parent was never that religious, and now all of a sudden they're getting divorced, the non-custodial parent is acting really religious and trying to impose a lifestyle on you that you're not comfortable with. All of a sudden they want the kids going to yeshiva, and they'll be very generous with the money when it comes to yeshiva, but they won't be generous with it when it comes to food, shelter, and all the basic support. So you get this level of hypocrisy that can be quite frustrating. So in that
it's all about the control, Erin.
Exactly, 100%.
100%.
And that's why, again, when you're the custodial parent, and if you have in the back of your head that these can be, issues that come up, really the establishment of the school that the kids go to when they're young is so important, because once they're enrolled in the school and you kind of have that agreement and that status quo going, the courts really hate to disrupt children's education. So it's something to consider. And this is really where you see that overlap between custody and financials.
And just, this is total side point, but the courts hate to disrupt children's lives generally. So that that comes into play with, radius, where can people move? Can they move out of a certain area? And that, that relates back to finances also. What if the custodial parent can't afford to stay in the area that they previously lived? Can they move someplace else? And these are all complex issues that surround this. But now we're getting a little bit specific and off track. My faults. Okay.
I heard too. I like talking about tuition. Like I said, it's kind of interesting. And just as a side note, tuition can also include extracurriculars, summer camp, all that stuff.
Absolutely, tutoring, all of that. Very important. And but when I introduced the subject of add-on expenses, what I said was that the court would look at, in making that calculation, we look at all sources of income. Now, what happens when sources of income are not documented? What happens if somebody doesn't file their taxes, or their taxes don't accurately reflect what they're actually making? So in very simple terms, what happens if an ex-partner is working off the books? How do we pin that down?
These are the hardest cases, because the courts really do start off as the starting point with the tax returns, with the pay stubs, and they're saying, aha, I have this tax return. It shows $20,000 in income. Easy. I'm going to calculate spousal and child support based off of this tax return. And meanwhile, you know that the ex-partner made triple times that amount. It's just all in cash. So these are the hard cases, because now it's really your burden to show to a judge that this income exists. And if it's cash, that's really difficult. What these cases are called are imputation of income cases. And essentially means that, sorry, my slides were a little messed up, but what essentially it means is that the courts will consider not only just the income on the paper, but also the earning capacity. So for example, if let's say your ex-partner was earning $100,000 a year right before you separated, and then all of a sudden that income drops to $20,000, something fishy is going on. So the courts are not just looking at that number of $20,000 now, they're looking at what is this earning capacity and ability to earn in the future. They also look at lifestyle, because the lifestyle will show what income was available to pay for certain expenses. So one of the most fundamental documents in a case is either the financial disclosure affidavit or the statement net worth. These are the documents where both parties lift out their monthly expenses. If the monthly expenses are higher than the tax return income, for example, or the pay stubs, you got a problem here. Sometimes you can explain it if there's debt, but if there's no debt, it means that there's income floating around that allows the ex-partner to afford that lifestyle either before the marriage, during the marriage, or after the marriage, to show that there was enough, there was this earning history or an earning potential, or currently there's income coming in that's not being reported. Another,
Erin, if I can interrupt you for a second, it can be, remember, it's income from all sources. So it can be investment income. It could be money that's coming in from your family. Perhaps you have generous parents who are paying your children's tuition, or paying, monthly expenses for you, or whatever it is. That would all come into there. And that might explain why, for example, your tax return may say $100,000, yet your statement of net worth is adding up to $150,000.
Yeah, that is so crucial.
Coming from somewhere.
It's really crucial, because a lot of times I get a client who's saying, I'm so worried they're just going to say that their parents are paying for everything. And I'm like, great, get that admission, because that's income. Money from friends and families is one of the most common ways to establish imputed income. And another way is, this is something that you're not going to know perhaps when you start the case, but once the case starts underway, you're going to be entitled to the other party's bank account and credit card statements. If there's money going into those accounts that exceed what they're putting on their tax returns, that's another basis to show that there's money that exists here. Even if we don't know exactly what the source is, it exists.
Right. And it's important to, in higher net worth cases, it's important to follow that. In all cases, it's important to follow that paper trail, but things, in higher net worth cases, it gets complicated when you're following that. And sometimes you have to hire forensics in order to help you out with that, to establish what the lifestyle was and to determine what the income more likely is. So that's, things really can get complicated there, but it often pays off when things are so out of whack. When you're looking at it face value, it's not adding up, and you have to make sure that everything is available to you in order to correctly distribute it. And we're going to talk about distribution of the assets a little bit later on, as opposed to support, which we were just discussing now. So, we discussed support, child support, spousal support, maintenance. So we come to an agreement. Let's say you have a settlement between parties. There's an agreement that the parties are supposed to follow, or there may be a court order following a trial. There's a decision, and we have a finalized divorce with orders in place. But now what happens when the party who's supposed to be paying isn't paying? We actually received quite a number of questions ahead of time on enforcement, questions related to enforcement of judgments and orders. So how do we get a judgment to enforce a support order? People want to know, how do I enforce the judgment once I have it?
Yeah, and this was not initially part of our agenda for tonight, but we got so many questions about it that we felt like we had to address it. And quite honestly, it's one of the most frustrating parts about a financial case, is that you've done all that work, you get this order, you get this agreement, and it's not being paid. And one of the questions asked me, like, at what point in time do I just let it go, quote unquote? And I really love that question, because it's a personal decision, but I think understanding what those enforcement mechanisms are, the pros and cons, can help people understand, is it, at a certain point, is it worth it to be going after this money that it takes so much bandwidth just to collect upon, and it's keeping this abuser in my life? At what point is it, the path to empowerment might be letting it go? So let's discuss what the enforcement is. If you have an order or an agreement that usually is converted into an order, what I always advise is that the order or the agreement have the monies that are being paid to you payable through the support collection unit. This is an agency in New York that is essentially a middleman between the payee and the payer. So what happens is that the payer, the person paying, sends the payment first to the support collection unit, and then they forward those monies to the payee, the person who's supposed to be receiving it. And the great thing about the support collection unit that I find is that they track the payments. So we sometimes get these confusing things where the payer is paying late, making partial payments. It's no longer your responsibility to keep track of what's being paid and what's not. It's all done through the support collection unit. They keep a very clear record. You can start an online account, see your monthly disbursements. It's super, I mean, once you get the account, it's super easy to track. The second really great thing about the support collection unit is that if there's on the books income, and even in cases where it's not, but you can establish that the income exists, they can garnish the wages. So it becomes at some point not even a voluntary process for the payer. It's taken directly out of their paycheck and forwarded to you. And that is just like the most successful way to get payment, is when it's just not in that person's control. It's coming out of their paycheck. Another good thing about the
important thing, Erin, when we're talking about abusive situations, when we want to minimize contact between the parties,
yes,
we don't want one to have to wire money to the other or send it through electronic means. People are certainly very apprehensive about physically handing over a check. We want to minimize contact between the parties. On the other hand, I know that a lot of times some of my clients are not so into starting with support collections, because sometimes, there's a, it takes a while to get into the system. Things don't go as quickly. Once, things are moving well, it may take a couple of months. Then it generally is okay, but there is a little bit of a lag.
Yeah.
So for instance, if you're supposed to be getting on the 1st of the month, you may not get it until the 5th or the 10th of the month by the time it goes through, the process. So what I often advise my clients who are kind of wary of it is, so start off on your own. And if things don't go well, you can always opt in at that point.
Yes, you could. And you do that by sending your court order to the support collection. They will take your court order if you send it to them afterwards. But yes, another way of getting around that is to, let's say that the payments will start 3 months, like for the first 3 months, it's going to be going directly to you, which will give you time. I mean, it usually doesn't take 3 months, though. Honestly, with COVID, it's kind of a mess right now. But it usually does not take it usually doesn't take 3 months, but it could take like 6 weeks or so. So give yourself some breathing room to get the SEU, we call it the SEU time, to get your order, register it, get the account set up. That's another way to handle it. And yes, I don't mean to downplay. It is frustrating starting that account, but once the account is set up, it's one of the most smoothest ways to enforce a child support order.
I agree.
Another thing that SEU can do is that if the arrears that are owed on the account add up to a certain amount of money, they can suspend the payer's driver's license. They could prevent them from renewing a passport, which actually worked on one of my cases where the non-custodial parent traveled a lot for business and his passport expired. So he actually ended up paying a good chunk of arrears off just because he needed to renew his passport, which was just like one of those things. Like what I always say is that you never know how you're going to get this money in the future. You might kind of give up hope on it. And then like 3 years down the line, or somewhat, like there's something that happens in your case where they all of a sudden need a passport, for example, and they'll pay off some of those arrears. So the support collection unit is like the #1 starting place that I advise for collecting a child support. In terms of a fee, it's like $25 a year. It's a nominal fee. Another way is to bring an action in court for a money judgment order. The advantages of this is that money judgment orders go on someone's credit score. So if you get one, it could really freak out the payor, and they might want to pay off these arrears so they don't have this money judgment order. It's also collectible. So this really is effective when the paying spouse has assets. If you get a money judgment order, you can attach it to that asset. So if they have a house or a car or a bank account is really one of the most common ways, they can attach it to that asset. And essentially, if there's money in that bank account, they'll take the money from the bank account. Or if they ever try to sell the house, you're now listed as a creditor on the house and you'll be entitled to proceeds of that house. Or if there's a car, even the sheriff's office might even be able to seize that car and then give it to you. So if there's assets involved, that's a really powerful enforcement mechanism. And the third enforcement mechanism is filing a contempt case in court, asking for something called willful violation, which means that this person is purposefully not paying child support. If you're able to establish that, the remedy technically is that this person could be theoretically put in jail for willful contempt. It's a really high standard. It's not easy to get, but the scare of it is sometimes enough to get a settlement on the case. The courts really don't want to be involved, so they might lean on the other person to start making payments, saying, if you don't make some payments, I'm going to throw you in jail. So it's trickier in concept, but it is definitely something that can be successful.
Not too long ago, actually, during the pendency of a case, so during the divorce process, there had been a pendente lite order. Pendente lite means temporary, a temporary order for support. And I was representing wife. Husband was not paying and was not paying. And I actually succeeded in getting him found to be in contempt, and he was literally taken away and handcuffed in Supreme Court. That's really unusual, right, Erin? How often do you see that?
I don't. I have maybe like one case where we're getting there, but it's really unusual. And it's also sometimes at that point, it's not even about the money. It's just that visual image of this person who's done so much to you being taken off in handcuffs. Right. I mean, it's a little crazy if you think about it. Sometimes they get away with it after physical violence, but it might kick in with the financial abuse. Mm-hmm. So it could be very validating, but it's a really, I mean, depending on the facts of your case, especially if there's partial payments being made, those are the trickier ones. It could be a really long road and a draining road until you get to that point.
Absolutely. Absolutely. So, it's definitely unusual for that to happen. And it, don't expect that. Most often it doesn't. And, I would love to ask the question, but unfortunately I know the answer. Is there justice here? Are people always getting what they deserve, what they've agreed to, what's been ordered by the court? Unfortunately not. And it's, it's a complicated process, and you often have to do a cost-benefit analysis, both by way of finances. Is it worth the court process? Is it worth the emotional toll? I know often you and I were discussing this earlier. In abuse cases, sometimes it's just more empowering for a survivor to say, you know what, I'm going to do this on my own and I'm going to walk away. But it takes a lot to do that because we can't, it's very expensive to do that as well.
It is. So you're paying a lot to walk away, but it takes a shift in mindset and to understanding yourself and what at that point in your life now, what are the priorities? Because they shift over time.
Right. And that's, everybody has to make their own decision there. There isn't one right answer. What works for one survivor, one party in a divorce or in post-judgment doesn't necessarily work for the other. It's not a one-size-fits-all. And this is really something that you have to discuss with your attorney or come to an informed decision on your own with. So, Erin has very thoughtfully laid out different avenues and ways to deal with enforcement, but it really, it's on a case-by-case basis. So a few minutes ago, Erin, you used the word asset. You use that word in describing what people have, okay? And that's basically the easiest way to describe what an asset is. It's something you have, okay? It's something that you've accumulated. How are those things? How are assets distributed in a divorce? We've already discussed support, okay, direct support, indirect support, but how do parties distribute what they've accumulated during their marriage? The term for that is equitable distribution. When we're talking about the law in this webinar, we are discussing New York state law. Okay, that's important to put out there and to remind.
Yeah, we should have done that earlier, yes.
Yes, we are discussing New York state law, and New York state, we have equitable distribution. Equitable distribution does not necessarily mean 50-50. It's often very close to it. That's a rule of thumb, but the law is not 50-50, okay? It's based on equity. And we talk about the division of the assets. Okay, and assets can be anything from a set of dishes to a multi-million, dollar real estate portfolio and everything between your checking account, your savings account, your investments, your home. Okay, the marital residence. Those all fall under assets. So, Erin, more specifically, what are marital assets? What assets belong to the marriage?
So rule of thumb, a marital asset is anything that was acquired from the time that you were married to the time that one of you filed for divorce. So it could be anything like Rachel said, a retirement account, jewelry, anything that has value to it. And this applies to debt as well. So when they're dividing the assets, they're also dividing the debt. Now, there's certain exceptions to that. For example, an inheritance is not considered a marital asset. So even though it was acquired during the marriage, it's considered to be belonging to the person who gets the inheritance. Another type of example
Erin,
is,
one second. I'm just going to chime in there because I see that we got a question actually that involved inheritances. It was actually very specific fact pattern.
Yes.
So whoever sent that in, we read it, we reflected on it, but it's really too specific for this webinar. Please call us at Sarah's Voice, and that can be discussed more specifically. I apologize. Continue, please.
Yeah, so inheritances generally belong to the spouse who got that inheritance. And similar in that vein, a gift from a third party to specifically one party, even if it's not an inheritance, is generally considered that party's separate property. But if it's a gift to both parties, it's now a marital asset. The most important thing with marital assets is that it doesn't matter what name the asset is under. It matters when it was acquired and the source of income or funds that gave you that asset. So if it's coming from marital money during the marriage, it doesn't matter that it's only under one spouse's name. It belongs to both of them.
Right. So if you open a bank account in your own name during the marriage, is it about the name on the bank account?
No. And it's also not wrong to do that. Like we get a lot of questions a lot of times, can I open up a bank account during my marriage and not put my abusive partner's name on it? Yes, you could do that, but just keep in mind that the money that's going in there needs to be disclosed to the court later on.
Absolutely. And that's part of financial disclosure and that statement of net worth that Erin spoke about earlier. Now, what's not marital? Okay, what's not marital is, as Erin just said, something like something that was a gift that was just given to one party, okay, or an inheritance. Things that are also not marital are things that assets that someone came into the marriage with, okay, generally. If it's mixed or other events may transpire that would change the status of that. But if somebody comes into the marriage with let's say a house or an apartment, somebody comes into the marriage with that, it is presumed that that property is separate with exceptions. Okay. And that's, increase in value and, updates that you may do to it and contribution and all that. There are, a lot of complex factors. However, if you come into it right off the bat, there's a presumption that you would probably get some kind of credit. Okay. So when we're talking about assets that are separate, whether they be premarital or separate, when they were acquired during the marriage, during a divorce, we have to discuss what would happen with those credits when we're distributing, with those assets when we're distributing the assets. And we often use the word credit in that regard, because if a actual asset is not liquid and can't just be sliced down the middle and divided, then we might deal with it as a credit.
I want to also raise, there's another term of art in the legal profession that they call commingling. This is when you take a separate asset that might have been yours from when you came into the marriage, or let's say you got an inheritance during the marriage. When you combine that with marital funds, so let's say you had the separate bank account going into the marriage, but then you start depositing your marital paycheck in there. So after your marriage, you're putting in your wages. You're going to start kind of like smushing, I know that's not the best word to use, but you're putting all those assets together to the point where the court can't tell what was yours and what's marital. That's what's called commingling, when you make the nature of the assets so intertwined that the courts can't decide what was whose. You're going to end up losing the separate nature of that asset, and then the courts are going to end up, essentially just putting it as part of the pot. So this is why, and we'll talk more about it in webinar number 2, is the documentation that we're going to advise on that to prevent that from happening, or to establish that the separate asset existed before the marriage, so you can protect that asset.
But by the way, another example of something very similar that turns out very different is, for example, a retirement account. You're working before you get married, and there are monthly contributions to that retirement account prior to your marriage. Everything prior to your marriage would be considered separate. Then during your marriage, you continue making contributions into that very same account, okay, it's very easy there to see
Exactly.
a cutoff date and to distinguish between the premarital contributions and the contributions made during your marriage. And contributions made during your marriage would generally be considered marital, while the contributions made to that retirement account prior to your marriage would be considered separate.
Yeah, 100%.
Okay. All right, let's move on. Okay, so often people are worried about their ex-partner transferring away assets or hiding assets. What can be done about that?
So the strongest form of protection, honestly, I know people don't always like to hear this. I advise the strongest form of protection is to file for divorce, because once you file for divorce, what goes into effect is what's called the automatic orders, which I'm not expecting you to read all of this right now, but in essence, this means that once you file for divorce, neither party is supposed to make substantial changes to the nature of the assets. They're not supposed to sell away, transfer, take someone's name off of an account. Essentially, it's supposed to be, the assets are supposed to be a snapshot for the court. At the time that the divorce was filed, this is what the financial picture looked like. So the court can understand, okay, this is the pot that I have to work with when distributing the assets, and the same thing for debt.
And you know, Erin, on the statement of net worth, which we've referenced a few times, people are required to fill in a few different points of time, if you will.
Yes,
a few different snapshots. How much was there initially? How much was there at the time of the filing for divorce? And how much is there now? So we're talking about a checking account, right? What was the initial balance? What was the balance on the date the divorce was filed? And what was the balance today? And all those different dates have different implications.
Yeah, and I will say, like, with the bank accounts, you know, I get this question a lot. You can still, you know, take money from the bank account for your ordinary expenses, but just make sure you're documenting it. You don't want to be the person who takes out $2,000 right after a divorce was filed in cash and you just have no paper trail of it. So, you know, if you need money for food and shelter and you're paying the bills, that's okay. But just keep in mind that the snapshot the court is mostly going to target in on was how much was this account worth at the time that the divorce was filed. And if there's a reason that the account is worth less now, you need to answer why.
Right.
And the same goes for the other side. So if you're worried about your ex-partner selling the house from under you without, you know, taking your name off the deed or whatnot, they're not supposed to do that. They're never supposed to do that. But once the automatic orders come into effect, at this point, they're violating a court order and it becomes much more serious.
Right. And it applies to all financial aspects, to your bank accounts, to your property, to your life insurance. All those things are affected by the automatic orders.
Health insurance as well. You're not supposed to change the beneficiaries on a health insurance plan.
Right. Right. Okay. What about taking money out of savings? How does somebody support themselves?
So again, you're allowed to do that if it's for basic household expenses, but this is not the time to buy something extravagant. Really just live by the book, because you have to justify these expenses in court later on. Court.
We keep talking about court. What court? What court are we talking about? Where are we filing? What judge? We keep using those words. Court, judge, they're looking at things. We're going to have to justify things. Where is this happening? Where
basically, family court, which is a court that you can enter without being married, or even if you are married, it doesn't matter. You can file for child and spousal support. So those cash amounts that we were talking about at the beginning of this webinar, you can do that in family court. Supreme Court, you can only go to Supreme Court if you're married. And the way you do that is by filing for a divorce case. And the divorce case can do everything. So you can do the divorce, child, spouse support, and that division of property and debt. Now, as I said earlier in the webinar, COVID-19 has impacted where you can file. Unfortunately, the family court are not actively calendaring new support cases right now. So they're accepting by mail. If you mail in your petition in New York City, they'll accept it, but you won't get a receipt that they actually are calendaring it. You're not even going to get a file number. So they're kind of just sitting there right now. And it's going to take time before they're able to put it on the calendar. So right now, unfortunately, the only way to apply for support is through the Supreme Court and as part of a divorce, which you might decide if you're married that that's where you want to be anyways. And there's, you know, we can't get into it in this webinar. There's various advantages and disadvantages to each forum. But right now during COVID-19, if you need support, practically speaking, the only way to really get it as a court order right now is through the Supreme Court.
And you can't, you know, just to reiterate, you cannot get divorced in family court. So if your goal is divorce, Supreme Court is where you need to be. Right. So more can be achieved in Supreme Court. The speed is what, you know, what you get there, and, you know, processes may be different, but the only place that you can get divorced is in Supreme. And it's important to know that. And
if you have assets or debts that you're worried about, then again, you want to be in Supreme Court, because then you get those automatic orders and the property can be addressed there.
Absolutely. Okay, but what if somebody is only got married religiously? Do they have to file for divorce? Can they file for divorce? How does that work?
So this is a really good question. And the answer is yes. If you're only religiously married, you can absolutely file for divorce, because New York recognizes religious marriages as valid marriages in New York. You do not need a marriage license to file for divorce in New York. So this is a really big key point. And we actually recommend that people who are religiously married only, even if they have their get, to still file for the civil divorce, to make it very clear on paper that you are now disconnected from each other, especially if you file joint tax returns, because that means there's paperwork out there that has you two listed as married. So we actually encourage people to file for that civil divorce.
Right. You could still be financially responsible for one another. So under, you know, in the eyes of the law, you want to be seen as, you want to actually be divorced and no longer responsible for one another in that way. Mm-hmm. Okay. But what, how does New York State look at a religious divorce? How does that come into play? Does it come into play when discussing the financial aspects of a divorce?
So my organization, Shalom Task Force, we consider get refusal as a form of abuse. And fortunately enough, New York State is really trying to move in the direction where this kind of abuse is considered when it comes to financials. So in New York, there's something called what people colloquially refer to as the GET laws, which means laws that the New York legislature has passed to address the denial of a GET. It applies to, honestly, to all religions, not just the Jewish religion. So the first one that we historically know about is GRL 253, which is that if you are starting a divorce case, if you're the plaintiff, as part of your obligation for starting that divorce case is that you need to what's called remove barriers to the other spouse's remarriage, which means that if you're the husband, you need to provide a GET if you want a civil divorce. If you're the wife, it means you need to accept the GET as part of your civil divorce. That's the first most well-known GET law. But what we were finding is that because this GET law was so well-known, what we saw a lot of times was that abusers who did not want to give a GET were not filing for divorce. They were waiting for the wife to go first. So recently, actually, in about 2015.
Erin, can I interrupt you just for a second, just for clarity? Okay, in a divorce, there's a plaintiff and a defendant. The person who files for the divorce is the plaintiff. So it might be Mr. Cohn versus Mrs. Cohn. Mr. Cohn would be the plaintiff, Mrs. Cohn would be the defendant. So when Erin is saying the person who files for divorce is the one who's obligated under this law to say that they have removed all barriers to remarriage, we're referring to the plaintiff, and in my example, that would be Mr. Cohn.
Yes, exactly. Thank you. So in about 2015, New York actually amended the equitable distribution and the maintenance guidelines to include denial of a GET or removal of barrier to remarriage as a factor that the court can consider when deciding who gets what with the property and how long the maintenance or how much the maintenance is going to last or be. Like I said, those kinds of areas of law, the maintenance and the equitable distribution, it essentially goes on what the court thinks is fair. It's not like for equitable distribution, it's not straight up 50-50. If there's a factor involved where the court thinks it's justice, like again, justice requires for one spouse to get more of the assets, they could award that spouse 60, 70, even 100%. So refusal to provide a GET can have really strong consequences to the spouse who's refusing to either give or accept the get. And I want to mention there's also case law on this, that before they amended the law, you already saw judges making decisions on this area of law by saying, you know, we have a case here where someone's not giving a religious divorce. So what we're going to say is that person does not have to give the religious divorce, because as we know, it gets not kosher if it's coerced. So they're not saying that you have to give the religious divorce, but what they'll say is if you don't give the religious divorce, you're going to forfeit whatever assets we would have normally have given you. So they can say you're entitled to this portion of the assets, but if you don't give the religious divorce by this and this date, you're going to lose it. Or in one case, the get
And the
refuser.
rationale behind that, if I might interject,
Yeah.
the rationale behind that is that if your spouse is not going to be able to move on as a single person, no longer tied to you, then you will have to provide to them, because they will not be able to get remarried and have that additional support from somebody else. So what you're saying is that what the court, what the law is saying here is that if somebody cannot move on, if you're not allowing somebody to move on, then you have to then be responsible for support of them.
Yeah, and it's pretty powerful, and it cuts the other way. If the person refusing to give the get is not the moneyed spouse, there was a decision where it said to this person, normally you'd be entitled to maintenance, but we're not giving you maintenance unless you give the get. So, right. And again, they phrase it in a way to make it less, you know, again, they're very aware of what the laws are with regards to the get and making sure it's a kosher get. So they frame the decisions very carefully.
Right, right. Okay. So we've been going through the different building blocks and the general breakdown and overview of financial legalities in a divorce in Supreme Court. We discussed family court. Now we discussed religious divorce and the get. This all brings us to the connection to Shalom Task Force, if you would, and to Sarah's Voice, where your specialty is the area that you concentrate most in are divorces that involve abuse. What is financial abuse? How does that play into the divorce process?
So this is really, this topic, it's so difficult to discuss because it's such a broad topic, but you know, in generally speaking, financial abuse is using money or finances to control the other partner. And this can look really different depending on the case. It's, you know, essentially hiding bank account assets, not telling someone what their income is, forcing the survivor to give all their income to the abuser. You don't know how they're spending it. And essentially it's creating control through financials, because as we said at the beginning of this webinar, if someone does not have financial security, they might be scared to leave a relationship, because how are they going to afford basic necessities if they don't have any access to money? We see a lot of cases where the survivor is encouraged not to work, and then they have this long relationship, and then they're left with nothing once the separation goes under. And you know, it's very difficult. So this is really this theme, which we're not going to be able to get into tonight because we're already running out of time, but this is what really was the brainchild for this webinar series, to talk about how these financial abusive practices, some of examples are listed on my other slide, how they can really complicate a financial case, and how they, you know, they create this level of desperation, if you will, in these situations that can lead people to make decisions that are not exactly kosher, that they normally might not have done, but in this abusive situation, they got to do what they need to do to survive. So for example, filling out a joint tax return with income that's not correct. So these are all areas that we're really going to explore in our next webinar series about how these financial abusive practices really play out in court, and what people can do to try to strategize on how to deal with these situations and how to get a court to understand what financial abuse is.
It's going to be it's very important also to make sure that you have an attorney like Erin, who's really well versed in these kinds of tactics and practices so that these things can be explained to the court, so that when a tax return is brought to the court and there are things that are inconsistent there, your skilled attorney is able to explain that. And that also, that goes back to the discussion we were having a minute ago about the get law and practices in obtaining a get. You have to make sure that your attorney is well versed in religious law and in the baked-in process and how that would all play out in getting your get. And Erin mentioned quite a few times that making sure that a get is not coerced, very important. And you have to make sure that your attorney is able to help you achieve that in a way that is not just civilly appropriate, but that is halachically appropriate as well. That's, it's really important to point that out, and not every attorney is skillful in that. And that's why Sarah's Voice is really such a wonderful resource to the community, because it is culture, the attorneys at Sarah's Voice are really culturally sensitive and understand all the issues that come up in the interplay between the civil aspects, the religious aspects, and the various courts as well.
Rachel.
Yeah. We've received, Erin, we're coming to it's quite late now. I'm looking at some of the questions that have come in. Quite a few of them have been actually about financial disclosure. So I'm just going to address that pretty globally, okay? In addition to the statement of net worth, which we have discussed several times this evening, there has to be financial disclosure in a case, okay? There's discovery. We call that process discovery, where both spouses have to hand over documents about their finances, bank records, retirement account records, information about any property they may have, such as a marital residence. All those things are really very important, and they need to be exchanged in order for everyone to evaluate what assets are here and how we're going to divide them. There's some specific questions here about workers' comp, also about, those things are all things that you'd have to do. That's very specific, and things that you need to discuss with your attorney, or call into Sarah's Voice, please, to address those specific issues. Interesting question here. Somebody said, my rabbi said that it's against halacha to report that my spouse works off the books. That's an interesting one.
It's a really interesting one, and that's really what we hope to just stress in the second series of the webinar, because these are so factually specific and culturally specific. As Rachel said, like, you need to have an attorney who understands the interplay of the financials and in the community that you work with. Like, I get a lot of people who say, I can't come into court and say this because it's lashon hara. So, there's no easy answer to this. It's really about doing some advocacy with the rabbi and hoping to make sure that the rabbi understands that if this information doesn't come to light in court, if the court does not have even allegations that there's off the books income, the amount of support that you're going to be left with is not going to be very substantial. So in terms of supporting the children, making sure that there's enough to support the Jewish lifestyle, which we know is expensive, and the tuition and all of that type of information, sometimes disclosing this, there are rabbis who feel like this is necessary to making sure that the children are being well provided for in the Jewish environment.
These expenses are not going to go away just because there's been a divorce. Somebody's going to have to pay for them. Somebody's going to have to support the children. The parties are going to have to be supported in some way. So if people are not forthcoming about their assets and in how much they earn, et cetera, then how could we possibly determine what is equitable and figuring out how to take one family and separate them into two different households? That's really the goal, is to do that in a way that is transparent and efficient. We have one more question here, just a quick clarification. What court are custody cases in? Is it both Supreme and family, or just family? And that can be achieved in both courts. Supreme Court and Family Court can tackle custody. What I mentioned earlier, what Family Court cannot do is issue a divorce. You cannot get divorced in Family Court. In previous webinars, Erin and I discuss orders of protection in both courts, and you can refer back to our website for that. Those webinars are cataloged there, as this one will be as well. So we're running late for this evening. So Erin, it is time for us to say goodbye, and we hope to see you next Monday on August 17th, same time, same place, and we will move on to part 2 and continue our discussion, really focusing more on financial abuse, strategies to address these challenges, how to protect yourself financially pre and post separation. You know, the earlier you start thinking about these things and planning for them, the better off, you know, you could be. Education is key, as Erin said. Everybody should always know their rights. And then we'll get into financial literacy tips and strategies as well.
I will say this is also part of the webinar where we'll talk more about the financial disclosure. So the questions that we got around that, that process will be elaborated more in the second preview. I just want to also make a plea to everyone who's listening is that, you know, if this resonates with you, if you know someone this resonates with, because we know we're not reaching everyone, the financial literacy, the empowerment, the strategies, it's really crucial, as Rachel said, to start early. So if you think this is information that could be helpful to someone, please, you know, I think it's very important to start this dialogue, especially in our community where we don't talk about the financials all the time, but maybe behind the scenes, you know that something's going on and they're talking to you privately. This kind of information is really crucial in helping them, you know, just in case there's ever a separation, this would help them put a better foot forward in court.
Absolutely. Tonight was a lot about the building blocks and financial information and divorce generally. Next week will be the meat and potatoes, the practical advice, the tidbits that can really help you or a loved one going forward. So thank you for joining us this evening.
Just one last word. If you need to reach us, this is our contact information. Sarah's Voice has a call and a text line at this number over here, or you can email us. You'll be put in contact with our amazing victim advocate and paralegal who put together these slides, and she will do an intake with you and connect you with an attorney. If you need to reach our confidential hotline, which does things beyond legal services, that's this number over here, the 718 number. They also have a WhatsApp and a text chat line. And like Rachel says, they're open today until midnight. Thank you very much.
Thank you for joining us, and thank you very much, Erin.
Thank you.
See you next week. Have a good evening.
You too.